Good morning all. Today I am taking a lecture on concern, in which today's lecture uh, in this I am including the exceptional things and the principle of consent, criteria for the capacity to consent, and the person without capacity to consent, and some other things which is essential for the related to the consent form. So, in the previous lecture we have studied about the consent. So, just we are taking one look about the consent, that is what is it? That is agreement, compliances or permission given voluntarily without the compulsion. So, it is important in the clinical trials or is in medical importance or in the practices. That is refers to the willingness of the person to the subject himself for the examination, investigation or the treatment. So, what is autonomy? That is a Nuremberg Code in 1947. The Declaration of the Helsinki 1964 informed the consent for the medical research. Section 13 for the Indian Contract Act 1872. Two or more persons are said to consent when they are agree upon the same thing in the same sense. So, the doctors are the God and paternalism. Present day, the significant changes in the doctor patient advice and patient rights make the treatment and select the physician of their choice. The generally we are using present day the Google. All the information we can gather from the Google um, search. What is COPRA? That is the Consumer Protection Act. That is a legal requirement, then a ethical, moral and obligation on the part of the doctor. The important aspect of the severe medical consumer litigations is important concerns. So, what is completing the documents about the concern? First, we will discuss what type of concern it is. It is a concern is a implied and express concern. That is of express consent is of verbal, written and the consent form. Implicated concern is a patient present himself as a doctor's clinic or an outpatient, implicated that he is agreeable to the examined. Only the procedure like the inspection, palpation, percussion and uh, osculation, that is essential. Then express consent is specifically stated by the patient in the language. Oral, verbal consent, relatively minor examination or the therapeutic procedures in presence of disinterested parties like nurses, like rectal and vaginal examination and withdrawal of the blood from the diagnostic purpose also. And in about the written consent, all the major diagnostic procedure like general anesthesia, operation and participation in the medical research. That is informed consent. Okay. Now, before moving forward, first we will discuss about different things like completing the documents. All the blank spaces should be completed. No addition or the deletion and the signature should be obtained. FDA 21 CFR 50, the patient's authorized representation shall sign and date and inform consent. 45 CFR 46, signed by the patient or the legally authorized representative. ICS GCP E6 4.8, informed consent should be signed and personally dated by the subject or legally authorized representation. That is called the institutional policies. Okay. So, the documentation also, the FDR 21 CRF 50, the copy of informed consent shall be given to the patient or the representative. So, the both parties should know that what they are doing and what the samples and what the consent is given by the patients. Okay. So, the 45 CFRC 46, the copy shall be given to the person signing to the form. And ICS GCP E6 4.8, the subject should receive the copy of signed and dated written informed consent form. Now, when do you need the witness? The witness is needed when the presenting the informed consent document orally and use of short forms and if required by the IRBs. Okay. So, who can be the witness? The ICS GCP impartial witness, the person who is independent of the trial, who cannot be unfairly influenced by the people who involve in the trial, who attend inform the consent process. Now, what is decision making capacity? Decision making capacity is often referred to by the legal term uh, competency. The decision making capacity is not black and white. The component of the decision making capacity are as follows, like one, ability to understand the option, the ability to understand the consequences of choosing each of the options, the ability to evaluate the person cost and benefit of each of the consequences and relate them to own set of value and priorities. And if you are not able to do all the components, the family members, court appointed the guardians or other determined by the state law may act as a surrogate decision makers and make decisions for us. Next, to have a decision making capacity does not mean that we have a patient we always make good decision or decisions that our doctor agree with. Likewise, making a bad decision does not mean that we as a patient are incompetent or do not have a decision making capacity. The decision making capacity or the competency simplicity means that we can understand and explain the option, their implication, and give the rational reasons why we are and why we would decide to participate option instead of the others. So the revision to informed consent. The informed consent document must be revised every time new safety information becomes available to there is a chance in the trial procedure, the participation and compensation or personal noted on the consent form. Next is to revision to be informed consent document must be approved by the IRB, IEC and prior to its use, and the informed consent process with new information and documentation need to be repeated with every clinical trial participant. The participant is then required to sign the revised form. Now, how does informed consent apply to the children? So the children are the exceptional cases. Okay, children do not have a decision to making capacity to provide the informed consent. Since the parents and other surrogate decision makers may give information or informed permission for the diagnosis and the treatment of the child, preferably with assessment of the child whenever it is possible. Sorry. Other disagreement is care may be result in court orders that specify uh, what treatment should occur. For example, blood transfusion or in court order appointment of the guardian that to make the medical decision for the child. Depending on the type of research, the IRB may make provision for the assistant of the children. The assistant, a child affirmative agreement to be participant in the research, may failure to obtain such, it should not be absent affirmative agreement be constructed as assent. Now, the now the consenting minors. Minors could be the maybe the below 18 years. Yes, the subject and the person obtained the consent signed by the ICD, and no, if they are not, so parents and guardian, witness and the person obtaining consent sign the ISD, sorry ICD, and child age between the 7 to 12, verbal assessed only, and child 13 to 17 written assent only required. Now, what is informed consent in the pregnant women? The doctor or the researcher should obtain the informed consent from both her pregnant woman and the father. Consent of the father is not as necessary if the purpose of the study is to meet the health need of the mother. The identity or whereabout the father cannot be reasonably or certain. Now, what is informed consent from the non-English speaking person? Ideal is to use the consent translated to the participant the native language. The copy of the consent document must be given to the each subject, while the translator may be helpful in facilitating conversation with non-speaking English subject. And verbal translation of the consent document must not be substituted for the written translation. Informed consent in the illiterate person. An investigator may enroll the individuals who can speak and understand the English. The potential subject must be able to place a written marks on the consent form. After that, the subject must also be able to uh, comprehend concept of the study and understand the risk and benefit of the study as it is explained and verbally, and be able to indicate approval and disapproval for the study enrollment. When the patient is incapable, some factors may make the patient incapable of providing the complete consent there temporarily or permanently. That example includes the mental illness or the mental retardation, alcohol or the drug toxication, altered mental status, and brain injury, being too young to legally make decisions concerning the health care. Now, what the 10 concern audit findings? The 10 concern first is the subject signature and a person obtaining consent on the different data. Number 1. Number 2, subject consent with a wrong version of the consent expired consent. Number 3, the subject concerned by the individual not named on the IRB's protocol. Fourth one is check boxes within a consent incomplete, that is a future use of the sample. Next is a cross out or the white out anywhere on consent documents. Next is unable to locate the consent for the subject on the study. And next is subject not reconstructed with revised consent, and ineligible subjects enrolled, wrong contact telephone number listed in consent, copy of the consent document not provided to the subject. These all 10 consent are required for the audit findings. Now, video and audio visualizing. Uh, Mainly high resolved camera, audible, clear, no other person involved, order to maintain the confidentiality, disturbance free room, CD can store at 5 years after the clinical trial. And what are the merits? We have to save investigators from the future legislations and increase the transparency rate. And what are the demerits? Long-term storage, on addition step increase and the time consuming process. Uh, what is about the summary? That is in form of the consent in the key documents, that is protecting the right of study the subject, procurement of the consent that ensure the human dignity of the participant and also show the respect of them, and it inform the consent that assure that prospective research subject will be understand the nature of the research and can acknowledgeable and voluntarily decided whether or not to be participate, and the investigation is primarily responsible for the ethics and practices of informing the person about their participation in the research as well as in the treatment, and the investigator should communicate the importance of the informed consent process to research staff, to the doctor, to the patient, and accept them to maintain the high ethical standard. So, uh, a lot of things are involved in the consent purpose, and mainly this purpose of the consent is to understand the work, understand the research, understand the legality, and that is responsible for the purpose to explain the person or the patient about the risk, about the benefits, about the alternative therapies, and they have to show their voluntary decision, participate or deny also. So, this is about the consent nature. Mainly informed consent and uninformed consents are there. So informed consent that allows the individual to determine whether the participation in the research fits with their values and interest, and to decide whether to contribute to the specific research project or to protect themselves from the risk, and to decide whether they can fill the requirement necessary for the research. And what is informed consent? The informed consent is communicated process in which the total information is passed to the patient or the research fellow, where that is between the researcher or the patient or the doctor and the researcher and the participant, and it starts before the research is initiated, continues throughout the duration of the study, and providing all relevant information to the voluntary or the patient, and the patient voluntary understanding the information, providing the voluntary agreement or the participant. That is a basic right. Okay. So um, mainly in this, the Balmer report is very much important. So the in Balmer report, although I have discussed in the previous lecture also, but just take a look about that. What is it? It is a expanded and definition of the informed consent and participant cap informed throughout the experiment and understand the risk and benefit. Okay. So in this elementary information consent form is there, that should be filled by the um, information consent form by the researcher, why the research is being done, what a researcher hope to accomplish, a description of what we will during the study and how long the study will be done, the risk factor for the participation of the study, the benefits of the participation of the study, and the benefits of the trial, and the verification of the right to leave the study at any time, and standard medical care. An informed consent document must be signed before the enrollment and may ask any question of the any time for that. Okay. And element that is involved in the informed consent form, that is the protocol number of the this, purpose of the study, duration of the study, subject of the involvement, the statement that the protocol and the informed consents, alternative uh, methods for the discussion for the options, and confidentiality of the record, and how much subject that are included, then compensation if there is any injury is there, and the question error, and the type of question, time of the question to be asked and the answer, and the description of the participant decision, then contact detail of the every participant and the patient or involved in the trial and the study, and those who are traveling, so their travel reimbursement it should be, and the subject responsibility, who has taken the subject responsibility, and subject satisfaction, and they use our understable language, and copy of concerns are given to the participant. So these all are included in this. So mainly readability is informed on the concern, that means language should be known by all the patient or the participant, the considerable comprehension as well as readability, and limit medical terminology, and mainly the information that should be um, permeable, or they will be partial. So we have studied about the copyright type of concern, and um, that is express concern, return concern, informed concern, and now we will doctorate inform the concern, that is that we want to study before move to the further. So the prospect of the success or the failure, we have to give the information to the patient, what is the prognosis after the treatment, or if we withdraw the treatment. The prognosis is in the absence of intervention. if if we are doing some intervention technique, so what will be the fate of the intervention, whether the prognosis is absent or it will be further. acceptance of the refusal, that is a informed refusal or said procedure of the invention. Okay. Now the now the consenting the age for the treatment, the age of the consent for the medical examination and the treatment, the legally accepted as more than 12 years. The child below the 12 years or the patient or the trial, in the trial there are some students if they are involved, so their concern, um, because their mind is unsound, so guardian person and who are the custodian for he and she can give the consent for that. And for the invasive procedure and for the treatment, for the diagnostic procedure, general anesthesia, surgical operations, and that concern, that is of if they are below and above 18 degree, below 18 degree or up to the 18 degree, 18 years, sorry, 18 years, so the concern could be given by their guardians. Now rule of the consent. Rule of the consent is a free, voluntary, clear, intelligent, informed, direct, or personal. It could be the free consent, voluntary consent, clear consent. It could be the intelligent consent, that is of the informed consent, direct and personal consent could be. Explain the object of examination to the patient, and patient should be informed and findings included in the medical reports, and right to refuse to the submit of examination, and that results may be go against him. So sometime the patient and the trial person can refuse their refuse to move further, so the result may go against him. Now insane or intoxication person unable to understand the nature and consequences, the consent is invalid, that is under the section 90 IPC. And section 92 IPC deals with a case of emergency. If the emergency is there, state that any harm caused by the person in the good faith, even without the person consent, is not an offense. Okay, without any concern in emergency, any decision can be taken. And in case of intoxicated person, the concern is invalid, that is of 90 IPC formulation. Now, the rule of consent of the spouse is not necessary for the treatment of others. Now, if individual can wants to treat the disease, so spouse consent is not applicable or necessary. And contraceptive sterilization and artificial insemination consent of the both husband and wife is must. In case of family planning, in case of sterilities, in case of artificial insemination and uh, test tube baby planation and any other fertilization, both consent of the both partners is required for the this. Okay. Now rule of consent, that is civil cases and criminal cases, examination not done without the consent of the person. In civil cases, uh, if there is no injury, there is no criminal cases, so examination is not done without the consent. So consent is required, then only it will be. And in criminal cases, victim cannot be examined without the consent. Okay. So the under section 53 I1 CRPC, accused can be examined by the doctor by using a reasonable force if requested by the police office. Okay. So in criminal cases, if the person is not ready to cooperate, so it could be some reasonable force if it is requested by the police officer. Now, the organ donation. The rule of consent, the will of the deceased is enough, and prenatal diagnostic procedure, informed written consent of the pregnant woman. So if the person who wants to donate their organs, their prior consent is required, and written consent is required that he and she wants to donate his and her organs for that. And for the perinatal diagnosis procedure, that in this the written information, written consent form of the pregnant woman is required. Now, in pathological autopsy, consent of the next to the kin of the deceased, and medico-legal autopsy does not require any consent from relative or the um, deceased. In case of any reasons, it is if the case is of medico-legal case, so there is no consent is required for the doing the autopsy in the medico-legal case, and in the pathological autopsy, consent of the next of the kin of the deceased. Now, loco patients, that is Latin in the place of parents. Okay, the emergency involving children, parents, guardians are not available. Uh, so, in place of parents, anybody can give the loco parenting and parent in charge for in case of emergency. Consent of the person in charge of the child, that is in the school teacher at the picnic somewhere else where the emergency is there and the parents and the guardians are not available. So in this case, loco parents or the Latin place of parents जो है consent is required and can be given. Okay, now all the consent we have taken, whether they are valid or not valid, it should be we have an idea about for that. The consent is invalid if, so the consent is if invalid if they not and inform the consent. ये they are invalid if they are not informed by the consent and given for the committee a crime or illegal act such as criminal abortion, or obtained by the misinterpretation या misrepresentation or the fraud, and no legal capacity to give it. That means you are not capable to give the sub consent and you are giving the consent, so they are useless. So in the four categories, the consents are illegal or invalid, that is minor or insane persons. Now, exception to inform the consent. Emergency. In the emergency, that is of section 92 IPC, the 17-year-old boy, severe crushed anesthesia is required, and inform the concerned anesthesia boy and his parents. In such type of medical emergency, exceptions are there, and in this type of emergencies, consent is not required or consent is given by the doctor itself, and the treatment will start before taking any consent. To the in front of a police officer, the doctors can give the consent and they can start the treatment. Okay. Next, exception to inform the consent, that is of therapeutic privileges. Doctor can withhold the information from the patients if the disclose would pose a serious psychological threat to the patient, that is malignancy and unavoidable total results. Okay, if the patient is not able in that position that they can hear that he is in in good, not in good health, so doctor will not taken a consent form for the treating of that, like um, malignancy or some socio-economic or psychological disorder where the patient get um, in problem. So in case exceptions are there, and disclose the full information to complete the relative to the patients. Now, Now, exceptions to inform the consent, that is of um, therapeutic waivers, that is a competent person who is aware to being entitled to inform the consents may give up his right by waiving it. So therapeutic waivers, that is also, that means that is for the right thing they will give the consent by the waiving. And some exceptions are there for the consent. There's a medico legal post-mortem, that like section 174 CRPCs, examination of the arrested excuse, section 53(1) CRPCs, and treatment of the patient that is suffering from the notifiable disease for the greater community interest, and psychiatric examination of the treatment by the court orders, and prisoners. So that is exceptions to inform the concern. Now, in case scenario, Sarita is unmarried 70-year-old girl. She comes unaccompanied in the obstetric OPD with an amenorrhea. Pregnancy test is positive and doctor inform her that she is 10 weeks pregnant. On questioning, she reveals that her relationship with the boy with neighborhood led a pregnancy, but he refused to marry as he belongs to the different community. So Sarita requested to the doctor to perform the termination of the pregnancy. She is afraid of the parents as they may harm her or send her away. She can not give a valid legal consent as she is only 17-year old. So consent to be valid, yes or no? Free, voluntary, without undue influence, given by the complete person and competent person, that is informed, that is nature of illness, that is prognosis, option available and risk involved, and the guardian, the proxy consent, and in case of mentally retarded, in case of minor, so consents are given by the guardians. So this is all about the today's lecture, uh, in which we have included the all aspects of the concern. So thank you very much for being with me. Have a good day.